Lindsay Clancy, she asked for help. So what happened? There is a question I keep coming back to when I look at Lindsay Clancy's story. She was asking for help. So what happened? And I don't mean that as a rhetorical question where I already have the answer. I mean it as the beginning of the legal conversation. Because by the time we get to January 24th, 2023, Lindsay's mental health had not suddenly appeared out of nowhere. There was a history, there were symptoms, there were appointments, there was medication, there was hospitalization, there were conversations with family. There were things Lindsay herself was saying, and there were professionals who were trying to determine what was happening. The question is not simply whether Lindsay was mentally ill. The evidence presented at trial makes clear that her mental health is central to the case. The question is what her mental state was, what the people treating her understood, and what that means legally. The timeline matters. According to testimony presented during the trial, Lindsay's mental health deteriorated significantly in the months following the birth of her third child. Family members described increasing anxiety, paranoia, suicidal thinking, fear, insomnia, and concerns about harming herself or her children. Her former mother-in-law testified that Lindsay was open about her struggles and was asking for help. And then there was professional treatment. Lindsay was seeing mental health providers. She entered a perinatal behavioral health program, but ultimately went to McLean Hospital voluntarily for inpatient treatment. And she was discharged after 5 days. That discharge becomes incredibly important because just 19 days later, the tragedy occurred. So now we're looking at a timeline that raises difficult questions. What did the providers know when Lindsay entered McLean? What did they know when she left? What symptoms did they observe? What diagnosis did they believe they were treating? And perhaps most importantly, what changed between January 5th and January 24th? The McLean question. This is one of the areas where the evidence becomes particularly interesting. Dr. Aaliyah Goodhart, the psychiatrist who treated Lindsay at McLean, testified that Lindsay presented with severe major depressive disorder without psychotic features. She testified that Lindsay reported insomnia, numbness, and suicidal thoughts, but that she did not observe clear signs of psychosis during the hospitalization. Lindsay was considered cooperative and was discharged with follow-up plans. That testimony matters. But so does the testimony from the defense experts. The defense's position is that Lindsay was experiencing a severe postpartum psychiatric illness, including psychosis and an underlying bipolar disorder, and that her condition was worsened by medication changes and other factors such as sleep deprivation and postpartum hormonal changes. And this is where we have to be disciplined. Those are competing interpretations of the evidence. We shouldn't take the defense theory and present it as established medical fact. But we also shouldn't take one provider's contemporaneous assessment and pretend that it answers every question about what happened afterward. That's why evidence is so important. The medication question. The defense has also placed significant emphasis on Lindsay's medications. The defense has argued that she was prescribed numerous psychiatric medications over a relatively short period, and that the combination and changes in those medications contributed to or exacerbated her psychiatric deterioration. A defense psychiatrist who reviewed the case criticized the quality of the medical records and raised questions about testing and treatment decisions. Again, that is an argument. It is not something we should imply, or we should simply declare proven, but it is absolutely something the jury is entitled to examine, as they are the finders of fact. Because if the defense is arguing that medication contributed to a psychiatric deterioration that ultimately affected Lindsay's ability to understand reality, then the jury has to consider the medical evidence supporting or contradicting that theory. And that means looking at the actual treatment history, not just the number of medications, not just the names of medications, but why was each medication prescribed? What symptoms was it intended to treat? What happened after it was prescribed? Were symptoms improving or worsening? Were there changes in diagnosis? Were there warning signs? Did the providers recognize them? Those are much more meaningful questions than simply saying she was on 13 medications. And then there are the symptoms. This is another place where this case becomes complicated. The defense has presented evidence that Lindsay described frightening thoughts and, according to testimony from family and defense experts, experienced symptoms consistent with severe psychiatric deterioration. Dr. Paul Ziesel testified that Lindsay later described hearing a male voice ordering her to kill her children and herself. He also testified that psychosis can fluctuate and that someone experiencing psychosis can still perform ordinary tasks. That last point is important because one of the easiest mistakes we can make is assuming if someone can perform a normal activity, they cannot be psychotic. Human brains aren't that simple. A person can have periods of functioning. They can make a phone call. They can drive. They can interact with other people. They can appear organized and still be experiencing profound psychiatric symptoms. But, and this is equally important, that does not automatically establish that someone was legally incapable of understanding the wrongfulness of their conduct. That is the legal question. And that's why this case can't be decided by a single symptom, or a single behavior. The prosecution's evidence matters too. If we're going to be fair to Lindsay, we also have to be fair to the evidence the prosecution is presenting. The prosecution argues that Lindsay's actions demonstrated planning and intent. They have pointed to her online searches and to ordinary activities she performed before the killings as evidence that she understood what she was doing and acted deliberately. That evidence cannot simply be dismissed because the defense has presented a mental illness theory. The jury has to weigh it. And this is where I think the public conversation often goes wrong. People want one fact to settle the entire case. That's not going to happen. It's a myriad. It's the totality of the circumstances, which is taken together. What is the most likely hypothesis, right? The most likely explanation that makes the most sense. She planned something, therefore she wasn't psychotic. Or she was psychotic, therefore she couldn't have planned anything. But human behavior and psychiatric illness can be far more complicated than either statement suggests. The legal system has to evaluate the evidence as a whole, or the totality of circumstances. So, what does the law actually ask? This is where the legal analysis becomes really important. The question isn't simply, did Lindsay kill her children? The defense isn't disputing that she committed the acts. The question is whether she should be held criminally responsible for them given her mental state. Massachusetts uses a lack of criminal responsibility standard in this context. So the jury isn't being asked to decide whether Lindsay was mentally ill. They're being asked to determine what her mental illness meant for her ability to understand the nature and the wrongfulness of her conduct and to conform her behavior to the law. That's a much narrower question, and it requires us to separate diagnosis from symptoms, from mental state, from legal responsibility. Those are all related, kind of nesting, but they are not interchangeable. And that's why I keep coming back to Lindsay asking for help. Because before we get to the courtroom question, there is a human question that deserves attention. Lindsay was struggling. She told people she was struggling. She sought professional help. She went into a hospital voluntarily. She continued treatment. Her family saw changes, and yet something went terribly wrong. That doesn't tell us the legal answer, but it tells us the story is more complicated than she was fine and then she decided to do this. There was a progression. There were warning signs. There were treatment decisions. There were competing interpretations. There were opportunities to understand what was happening. That's what makes this so tragic, guys. That's what makes this so sad. And there were things that in hindsight looked extraordinarily important. But hindsight is one of the most dangerous tools in legal analysis because we know how the story ended, and it didn't end good, as we all know. The people living through November and December of 2022 did not. They were making decisions with the information they had at the time. That's the standard we need to keep in mind. The question I want to leave you with: I'm not asking you to decide whether Lindsay was legally responsible. That's what the jury is there to decide. I'm asking you to look at the evidence differently. Don't start with the ending and work backward until every earlier event looks inevitable. Start at the beginning. Look at what Lindsay was saying. Look at what her family was seeing. Look at what her doctors were seeing. Look at the treatment she received. Look at what changed. Look at what the defense experts say. Look at what the prosecution says. And then ask, what does the evidence actually prove? Not what we wish it proved. Not what a headline says. Not what a TikTok tells us. Not what hindsight makes obvious. What does the evidence prove? Because that is where the law lives. And that's where I want Grace and Gavel to live too. Not in excusing, not in condemning, not in sensationalizing, in understanding. Because Lindsay was a person before she became a defendant. And understanding the person doesn't mean abandoning the law. It means we are finally asking the legal questions with the full human context in view. Thank you for tuning in to Grace and Gavel, where truth meets compassion. My name is Buffy. I'm an almost 18-year criminal defense attorney. If you got value from this, please consider liking and subscribing, as well as checking out Grace and Gavel, which is a true crime channel where truth meets compassion. Would greatly appreciate it. If you got value, please consider liking and subscribing. Thank you so much for your support. It means a lot, and I hope you have a great rest of your day, and hopefully you'll come back and see us again soon. Bye-bye.